So in this module, this is really an optional module, so don't feel like you need to watch it. But it's a topic that um, comes up fairly often, and it I just thought it would be useful to just do a quick primer on intellectual property in general. There's a lot of confusion about what forms of intellectual property there actually are and how all that works. So this is just meant to be a high-level overview. It's a little bit off the beaten path for our course, but that you might find interesting. So the first thing I got to do a quick little disclaimer. The the I'm not an attorney for the government. I'm a licensed patent attorney, but not for the government. So this comes up fairly often because if anybody ever asks, hey, is something that I'm doing patentable? One of the first questions that I ask is whether or not it was done as part of their job, because if it was, then the government has rights to it, and you need to go through the formal chain of going to the patent attorneys here at NPS or wherever your command actually happens to be. So that's just an important thing that you need to know, because we work for the government. If you're doing something completely private, then all of this will apply to you. Um, so what we're going to talk about a little bit today is, first of just walk through the different types of intellectual property and just a light touching on the law that governs each of them, so you understand what they are. Um, and then I'll walk you through the patent process, both in the U.S. Patent and Trademark Office, and WIPO is the World International Property Organization, and that's where you go. It's not the only place you go, but it's where you would typically go to get protection for a patent protection internationally. We'll talk a little bit about some current prosecution challenges, particularly related to software, which is important to us, and then I'll just touch a little bit on being a patent agent or an attorney. Um, so first of all, these are the main four things. If you understand what these four things are, you pretty much understand the nuts and bolts of intellectual property. And you need to know that patents protect an actual idea. So just because I implement something differently, it may still infringe on your patent. So it's the idea itself. Trademark protects your brand, has to do with consumer protection mainly. Copyrights protect your content. Protect your content. So that is very specific to the implementation, unlike a patent. Um, and trade secrets is a little bit of a catch-all. It often gets forgotten about this, but it's an extremely important element of intellectual property, and that sort of protects data and everything around it. It also can protect ideas and brand and content, but in a completely different way. So a little bit on the intellectual property ecosystem. Uh, the the all of our policy based on about patents and copyrights and things like mask works and plant varieties is actually in the Constitution itself. Um, Trademarks are loosely covered in the Commerce Clause, also in the Constitution. Trade secrets, rights of publicity and rights of privacy, which can all be related, really go down to state and federal law, but not the Constitution itself. So you're looking at U.S. code or state code for that. Um, First, let's go through patents. Now we're going to be talking about protecting ideas. So some examples from the Department of Defense. You look at weapon systems, a manufacturing process certainly applies. Software, patenting a GUI is particularly challenging. You might want to do something like a design patent for that. But software certainly is patentable with some challenges we'll talk about in a little bit. But lots of examples of work that was done for the United States government that ends up being patented. The U.S. government actually retains, can be the owner, would be the owner of the patent, but usually they will provide some type of a payment to the inventor, and sort of an honorarium sort of a thing for the inventor or inventors. And also, We can talk in a bit about how that can be licensed back out. Remember what we talked about in open innovation. You now have a patent that the U.S. government owns, but it may have a commercial application. It can be licensed back out to the private sector for all sorts of non-defense uses, or it can be licensed for defense purposes as well. A patent is actually, this is important, it's actually a contract with the government. It's an agreement. So you come up with some really great idea, and you're the only one who has it because you thought of it. And what you're agreeing to do if you decide to get a patent is you are agreeing to fully disclose your idea. And this comes up a lot with inventors because I want to get a patent, but I don't really want to say everything. I want to keep it a secret. Well, that's a trade secret. That's not a patent. So you are obligated, and if you want to get a patent, to fully disclose your invention to the public. This is part of the public policy, is that in return for you disclosing your idea to the public with enough detail that somebody that we taught, as we say, skilled in the art, can reproduce your invention, and in return, what you get is a 20-year exclusive property right. So that the government says, we will protect you. If anybody tries to steal your idea, you have the power of the courts that you can enforce your 20-year exclusive right. But what's in it for them is you've disclosed it to the public, and now the public can read your patent, and now they can build on top of what you did and maybe do something else that's patentable above and beyond what you did. So things that you need for a patent application, there's what is called the specification. So this is a full description. What we say is, someone of ordinary skill in the art. So if it's software, it would be something that we can use terms that programmers understand. We don't have to define them all. You presume that somebody with ordinary skill in the art would know how to do this. And you have to disclose it with enough detail that they can replicate your work without undue experimentation. So you got to show them everything. And what we normally do is we show what we call a number of embodiments, so a variety of different ways of doing it. You want to do that to protect yourself so that somebody can't work around you just by changing the way they did something and saying, well, I'm using different components than you used, so I can work around your claim. So you want to make sure you're as broad as you can be. You're going to have at least one or more figures to show how everything works, how it all fits together. And you've got to have at least one or more what we call independent claims. That's a claim that stands entirely on its own. And then you can have any number of dependent claims that are narrower than the independent claims and depend from them. So I can say I can have a claim that has components A and B. That's my independent claim. And then I can write a dependent claim where I say the claim of claim 1 further including C. So now it's narrower. It's got A, B, and C. Okay, and this is sort of an art in itself to how you write a claim. Patent prosecution is a negotiation, really, between the inventor or their representative, your agent or your attorney, and the U.S. Patent and Trademark Office patent examiner. It's interesting because you might think of it as the patent examiner as being adversarial, like I'm on one side and he's on the other, but I don't really think that's a fair assessment because very often they provide all kinds of helpful guidance on what you need to do to get your patent allowed and get it issued, etc. And no adversary would ever do that. So they really aren't an adversary, but they are the gatekeeper. Their job is to make sure that we don't have bad patents out there, that they are in fact defensible, and that if someone challenges them, they should be able to stand up to scrutiny. So they want to make sure that the claims are novel, non-obvious, and that they're fully supported by the specification. That's their job. Some general information about patents. We are now under something called the America Invents Act. That's really, we'll stop saying that fairly soon because it's been quite a while. So everything is now first to file. We didn't used to be that in this country. We used to be first to invent. So if I filed a patent application for my idea and somebody who didn't file before me but thinks that they invented it before me could challenge me, and if they could prove that they had the idea before me, they could potentially invalidate my patent. And you can imagine how messy that got. And the United States were late to make the switch. Many other countries had switched to first to file. It's so much cleaner. Basically, the courts say if you invented it first and you didn't get to the patent office in time, you lose. The other guy gets it. We have a thing called a provisional patent application. This basically preserves your priority rights. So these are never examined. They're actually fairly cheap. And what you do is you file just about anything with the patent office that says on this particular date, this is what I knew. And then you're starting a clock. You have 1 year with which to file a non-provisional application that claims priority to that filing. So what you could do is now you have a whole year to work on your idea. Now, before that year is up, you can now file a non-provisional application that will be examined that claims priority to that material. And that could be useful, especially in a hot area. Let's say you work in AI or large language models or something like that. That's really hot right now. A year is a lifetime. So you want to make sure you get the earliest date you possibly can. Now, an issued patent gives you the right to exclude others from making, using, or selling the patented invention for 20 years from your filing date. By the way, you might also think, well, what about all the time? Sometimes it takes you years to actually get your patent from your filing date. There are adjustments made for that. So if the patent office feels that any of the delay was due to slowness on their part, they will actually award you extra time. The inventors must be actual inventors. It's not like a paper you write for a conference where if somebody wrote a little code for you, you put their name on the paper. It has to be someone who actually contributed to the inventing. They're very specific about what that means. But anyone can be an assignee. So once you own, like for example, if I work for the Navy, if I invent something as part of my job, I can get that patented, and I am obligated to assign it to the United States government because I work for the government, and that patent was a part of my job. Therefore, I have to assign it to them. And you'll issue an oath or declaration that attests to all that. You should know that everything just about at the patent office has a fee. Any sort of a petition you want to file, any extension that you need, just about anything you need at the patent office, you can probably get it, but it's going to cost you money. So sadly, they're constantly putting their hand in your pocket, but that's the way they work. The governing law that you just want to know is 35 U.S.C. 101 is all about patentable subject matter. We're going to talk about that in a minute when we talk about patenting software, because very often software comes under the category of an abstract idea. So it very commonly triggers a 101 rejection, and you have to work your way around that. 102 is novelty. Novelty just mainly means that your patent, your disclosure has already been disclosed by somebody else before you in its entirety. That is one patent has everything that you're disclosing. That happens a lot, but it's fairly easy to work around those. The harder ones are going to be the 103 obviousness ones, because that's where the examiner says, well, Smith over here didn't exactly disclose your invention, but Smith with Jones, both of which predate your filing, if you put those two together, I have your patent. And so they'll claim that that's obvious. That's obviousness, right? That if I just put these two things together, that equals your patent, and therefore you can't get it. You can't get it patented. So you're constantly making an argument during patent prosecution that what they're claiming one of these patents says is not actually what it said, and that what you're doing is actually quite different. That's very common during patent prosecution. And then the last part of the governing law is what we call a 112. This just says the written description requirement. That's what we had already talked about, that you disclosed enough information that somebody was skilled in the art could actually replicate it. If you don't give enough information, they'll give you a 112 and say there's not enough here for anybody to actually replicate your work. There's something called an enablement requirement. You don't actually have to demonstrate that your software works or that your invention actually works, but you have to disclose enough that the examiner believes that that you do it's something that you have. It's not merely in your head. That you actually have the invention in your possession. And then the last thing is what we call best mode. And that just means that you can't withhold the best. You can't say I want to get a patent, but I'm not going to tell you the best way I know to do it. You can't do that. You're obligated to tell them what that is. A basic flow diagram on how patent prosecution actually works is you might optionally file a provisional. You don't have to. That sets a 1 year time clock and it cannot be extended, with which you have to file your non-provisional. And like I said, you can skip the provisional and go right to the non-provisional, particularly if you want to get your patent faster. Typically, it takes at least 1 to 2 years before your patent is ever going to be picked up and examined, and that can be exasperating that you have to wait that long. But it's quite a queue that you have to wait in. And then, lo and behold, one day you will get an examination. You get what's called an office action from your examiner that will give you a report and say, okay, I've examined your patent, and typically they'll say, I'm not allowing it, and here are the reasons why. And they have to tell you everything. And then you have to respond to that. You have to go through item by item and say, hey, this is why you're wrong, or I'm making these amendments. You can only amend your claims. If you amend your specification, you're in danger of adding new matter, which can trigger that's a violation. You can't add new matter after you've filed without changing your priority date and going back in the queue again. So you get these office actions, a non-final. You get for every when you do a non-provisional filing, you basically get 2 bites at the apple. So what you'll get is initially get a non-final rejection with full explanation of what it is. You now have an opportunity at no additional cost to respond to that and amend your claims. And then if that's still not good enough, the examiner will now issue a final office action, which it really shouldn't say final, because what he really means is final for this go round. Because if you believe that your patent is warranted and that you should get it issued, then what you'll do is you'll file what's called a request for continuing examination, pay them money, and you basically reset, and you now have 2 more bites at the apple. And you can just keep doing this, and they just keep asking you for money every time it comes around. Eventually, hopefully, you get to something called an allowance, where the examiner says, okay, you've made all the necessary changes. I can now allow your patent. At that point, you then will have a certain amount of time with which to pay your issue fee, and then eventually your patent will issue. And that's the way it works in the United States. You can go another route. The PCT, that's the WIPO, that's the Patent Cooperation Treaty with the World International Intellectual Property Organization, that allows you to file in one place. All countries, which is not every country, but it's a lot of countries, and typically it's the ones that you're going to want to get protection in, are members of this PCT, the Patent Cooperation Treaty. And therefore, you can make, with one fee and one filing, you enter what's called the international phase, right? So here you can file your non-provisional application. You have 1 year from the time you disclosed, and that includes it doesn't say this here, but it includes even if you filed a provisional. You have 1 year from the time you first disclosed anything with which to file your international application. That's also not extendable. So you file that, and now you have 1 to 2 years where you're waiting for your international search report, where that's the beginning of your examination. Approximately 30 months from your earliest priority date, you're going to have a trigger, which is also not extendable, where you have to enter the national phase. Here you have to select what countries do you want to file in. So let's say I filed, I'm in the U.S., I want to get international protection, I file a PCT application. At 30 months, I need to know where I want to file. Do I want to file in the EU? Do I want to file in the UK? Do I want to file in China, India? Where do I want to file? I also have to arrange to have representation there because your U.S. attorney is not licensed to prosecute intellectual property in any other country but here. So you're going to have an agent there, and they will represent you just like your U.S. Representation will represent you here. And then typically you can have parallel prosecutions going at this point. Very typical to sell. Let's say you have a U.S. application. If you file it internationally, at 30 months, you now will file in the U.S. as well as in, let's say, India. So now you've got two patents prosecutions going on the exact same subject matter, probably with the exact same set of claims in two different countries, resulting in two completely different patents. So that's the way that works. Some current patent prosecution challenges, particularly with software. There was a Supreme Court case called Alice versus CLS Bank, where they argued that the essentially that all you were doing was taking something that people already do and putting it on a computer, and that's not enough to be patentable. And that's in a nutshell what they were saying. But it has triggered all sorts of problems because the Supreme Court has really not yet even given us any sort of a decent test that we can apply to any new subject matter that will tell us whether or not it is an abstract idea or it isn't. And this has been a problem for a number of years now, where the first thing will happen is they'll say, well, software is allowable subject matter, so it passes step 1. But then in step 2A, they'll kick it out. They'll say, but it is directed towards a judicial exception that they call an abstract idea, and they'll kick it out and say, now it's not allowable subject matter. And then they'll ask, does a claim amount to significantly more? Well, what the heck is significantly more? There's no test for that. So it's kind of examiners are winging it on what does significantly more actually mean. And I will say that it's been getting a little bit better. Every time they issue new guidance, it seems to get a little bit clearer, but I still don't have any real confidence when I write a claim whether the examiner is going to feel like it's an abstract idea or not. So this is still an issue. Some strategies that you might think about if you're patenting software, though, is if you can tie it to a hardware element. Like one of the things I often do is we all know that if you write software that you can press software onto a custom integrated circuit easily. I mean, that's just something that gets done all the time. So instead of using a general purpose microprocessor, I can use a very specific purpose microprocessor that has your algorithm in it. So now that's no longer an abstract idea. It's a piece of hardware. And so that's one way around it. But then, of course, you're tied to the hardware. So one of the things that they're trying to protect is they don't want anybody to claim like a particular an entire field of endeavor. They want to leave it open for other people to come in and invent new ways of doing it, and you don't own all of them just because you're an abstract idea. That's really what they're trying to protect. And I don't know of anybody who disagrees with the policy and why they want to do it. It's just that the guidance on how they determine whether or not you're in violation is extremely fuzzy. So one of the other things you want to show is some type of a transformation in the invention. So you're transforming data in some way or something like that. You want to show how the function operations are not routine or conventional, so, particularly how it's something that a person couldn't do. And you want to show how show how the invention substantially improves the functionality of a computer itself or improves some other technical field. So these are the sorts of things that we look for when you're patenting software to get around a 101 objection. So you probably heard this term patent trolls. Just real quick, talk about what that actually is. It's basically a term that it's applied to what we call a non-practicing entity. So it's a pejorative term that is meant to imply a company whose business model is really litigation. So they buy intellectual property, so they buy up patents, and then they look for infringers and they sue them. That's their business model. And very often, because patent litigation is notoriously expensive, if you get a letter from one of these guys and you're already in business and you're selling a product, a lot of times it's easier just to pay them some money. It's, you may feel like it's extortion, and it probably is, but it's easier to just pay them and get a license from them so they'll go away and let you operate than it is to try to litigate. And they're counting on that. So you can imagine why this is a sort of a detestable practice. But here's the problem. Here is the real problem with it, is that while you might think, well, let's just pass some laws to make that illegal, the problem is that many independent inventors are also non-practicing entities. That means that I'm an inventor in my garage and I invent all kinds of cool stuff and I write patents for myself because I have money and I'm gonna get patents. Great. I'm working out of my garage. I don't want to start a company. I don't want to commercialize. What I really want to do is I want to license my stuff to companies that do want to commercialize. That's what I really want to do. But I'm a non-practicing entity myself, and I look the same as far as the law is concerned as a patent troll. Same thing is true of universities. We also look like non-practicing entities because universities aren't in the business of commercializing anything. But they love to have their intellectual property, of which they have tons, licensed to startups and companies that want to commercialize their stuff. So it's extremely tricky to pass a law that will shut down the type of patent troll that we don't like, that also doesn't step on independent inventors and universities. So it's tricky. I think there's lots of smart people working on it, but I think you can appreciate why this is an unsolved problem. A little bit about patents for government employees. There's guidance and rules about this. The main question is going to be whether or not your invention is linked basically in any way to your work. And we usually have a little bit of a broad mind about that. The mere fact that I am a programmer for the United States government doesn't mean that anything I program now has to be owned by the United States government. I could, go off and, create a cool thing for a video game, for a game engine, and, if that's not part of my job, I don't write game engines for a part of my job, then I probably can patent that on my own. Or I could do something for a completely different industry that has nothing to do with my government job. I'll probably be allowed. The safe thing to do is to see your local counsel and tell them what you did and why you did it and what it actually is, and get something in writing from them that says, yes, this is outside the bounds of your work. You're allowed to go off and patent it on your own. There's another thing that might come up too, where you do something that's patentable, or you believe it's patentable, and you go to your local JAG, and they say, yeah, that's interesting, but we're not interested in patenting that. One of the very first questions you might ask is, great, can I have a letter that says I can patent it? Because if they're going to say no, thank you, they may give you the rights, and now you can go off, but you're going to pay for it yourself and get it patented, but now you'll own it, because they've now given it to you. And the other thing is, what you'll often see is when you get it patented, when you get something patented as part of the government is going to have sort of a paid up permanent license. They own it, right? And you have whatever right your license agreement says you have. Okay, real quick on becoming a patent agent or an attorney. A patent agent is just somebody who can prosecute patents but can't do attorney things. An attorney is someone who can also prosecute patents but can do attorney things. It's interesting that the Patent Office requires that you have a technical degree, and they'll tell you what fields, what types of degrees they will accept. So if you've got a political science degree and you want to be a patent agent, you need to actually go and get a certain number of college credits in a technical field that they acknowledge before they'll even let you sit for their exam. And they there is a patent bar exam that you have to pass in order to be licensed with the patent office to prosecute patents. And if you want to be an attorney, then the law is a law. There's no patent law school. There's no special place you go to do patent law. You just go to law school. And patent law is not bar testable, so there won't be anything about it on your state bar exam. And then even if you pass your state bar exam, you still got to pass the patent bar before you can do anything with the patent office. Although there are a lot of people who are attorneys and do intellectual property, but don't prosecute patents. So like you can litigate, let's say a patent infringement, and you don't have to be licensed with the patent office to do that. That's just litigation. So that's just something to keep in mind should that ever be of interest to you. A little bit on trademarks. So this is about protecting brands. And the sorts of things you think about with a trademark is anything that indicates the origin or source of a product or service. So what this is meant to be is I need to know as a consumer that when I buy something, I can trust where it came from. So you do something like trade dress, you look at like a Chanel bottle is very distinctive. I can't sell any sort of cologne or perfume in the United States in a bottle that looks like that because Chanel owns that. They'll be able to sue me over that because I'm basically making people think that they're buying a Chanel product, but they're buying mine and it's not the same. Then there's slogans, right? So McDonald's, I'm loving it. Any sort of a slogan, you can trademark that. The actual shape, right? So a Coca-Cola bottle has a very unique shape. Even their plastic bottles and certainly glass bottles all have this particular sort of an hourglass shape that if you look at a Pepsi bottle, it does not look the same. If Pepsi ever tried to put out a bottle that looked like a Coke bottle, they'd be sued. So the shape is distinctive and it is patented, and it is not patented, but trademarked. Interesting that sounds can be trademarked. So you think about the bomb 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 of NBC, that's trademarked. And certainly logos, Levi's, that patch symbol is trademarked, as well as the name itself. Those would be two separate trademarks. Levi's is trademarked, and also the symbol. And also you should know that you trademark it, you're very specific to the field of endeavor. So Levi's is clothing, right? If I want to open up a hamburger shop and call it Levi's, they won't have any claim against me because that's not the business that they're in. Nobody would mistake my hamburger shop for Levi's, the clothier, right? So, and you'll see if you look up a trademark, it will always say description of goods or services to which that trademark actually applies, and they have to be very specific about what that actually is. Interesting thing about this also is that you have to be very clear about in what it is you're actually doing. So, for example, we've got here you've got Kodak as the color yellow, right? Imagine that Kodak now wanted to sell Kodak T-shirts, right? That's companies do this all the time. They promote their brand by selling clothing that has nothing to do with what their brand actually is. Right, so they're actually selling electronic equipment, or BMW it will sell clothes, right? They have to trademark that separately. They have to put a trademark that says that's part of what they do, right? Because BMW sells cars, they don't sell clothes. So if you want to sell clothes with the BMW logo on it, the BMW name, you got to protect that too. That's a separate trademark. Okay, a little bit on copyrights. Here you're protecting your content. So think about photographs, web pages, any sort of art. One of the things that we do a lot in our work is we copyright our code. So if you look inside the source file of Python code or C++ or whatever it is whatever language you're doing, you can often find up at the top a copyright notice, which is binding, right? Another thing I should mention about trademarks and copyrights: you have trademark and copyright protection even if you never file anything with the U.S. Patent and Trademark Office. You have rights no matter what. That's not true with patents. You have to file for patent protection. You don't have to file for trademark and copyright protection. Now you might say, well, then why would you? Well, you would because it strengthens your rights. You have what's called de facto or presumed rights as soon as you file for register a copyright or a trademark. Right. Another question that comes up, going back to trademark, is when can I use the TM? You can use a TM basically anytime. That just basically says I think this is a trademark. But if you ever see the R in a circle, that means it's registered. So an R in a circle always means that is a registered trademark. You should be able to look it up online and find their registration. And you should be able to find out exactly who it's registered to and what it's registered for. All that should be available. Okay, so protecting copyrighted works. So you want to make sure you obtain copyright assignment from all non-employees. So if you ever have like a company and you have people writing code for you or writing materials for you, you want to make sure you have language in their work agreement that makes sure that you own everything that they do. So any sort of work for hire, always have an IP clause in a work for hire agreement that makes it clear that anything they produce as a result of that contract, you own. That's very important. And you also want to make sure that the register materials that have to have sufficient value, right? So not every version of your code is going to have value. You don't want to register them all. I mean, you could, but that'd be a waste of resources. All right, last thing here we're going to talk about is trade secrets. So here you're protecting data, content, ideas, basically anything. So think about customer lists, supplier lists, any sort of private data that your pricing lists, key personnel, all that kind of stuff that may be a part of your company that and could be damaging to you if it were to get out into the public domain. This could all be trade secrets. There's two requirements about anything with a trade secret. First of all, you got to keep it a secret. And the second thing is the secrecy must have value. So if you have, let's say, a supplier list and you don't sufficiently aren't careful with it, like for example, let's say basically every employee in your company has a copy, and you don't even tell them that it's private data, and one of them goes and shares it someplace, you're going to have a hard time suing anybody who steals your supplier list, because they're going to say, hey, I got it from John. John just gave it to me. He works for you. Well, was that espionage? Well, no, John didn't even know that it was private, right? So you want to make sure that all things that could be damaging to your company should they get out, or that have value to you, that you protect them. You have to take steps to keep them secret. This can be doing things like encrypting them if it's digital type stuff. You can keep them online, but you got to take steps. You got to encrypt. You got to put them behind password, have a good password protection, all that kind of stuff, and that has to have value. And the last thing you want to say is you want to restrict asset, you want to make sure there's security levels, and you want to have confidentiality agreements, including with people that you might talk to who are not part of your company. So think about something like what you typically want to have what's called a mutual non-disclosure agreement. So you're talking with somebody. That means that anything I say to you, you can't share with anybody else, and anything you say to me, I can't share with anybody else. That's mutual. Those tend to be the more accepted type of NDAs that you're probably going to want to have in your hand if you talk to anybody. So that is a little longer than I had planned on, but it's a good intellectual property primer. So you just sort of can you at least know what these words mean and be able to define them and know the difference between them. We didn't talk about some other things like there's something called a plant a patent, so a variety of a plant. There's also something called a design patent, which is very much like a trademark. So you have a product that has a particular type of a look to it, you can actually get a design patent. So that bottle of Chanel perfume, for example, could have a design patent behind it to have a very distinctive look about it. But what you're patenting in a design patent cannot be utility. And you can never claim utility in a design patent, nor can you claim design in a utility patent. They are mutually exclusive. All right, so I hope this was helpful, and that you'll find it useful in whatever it is that you do.